Good evening, folks. Welcome to Kirk's Law Corner on Friday night, fun night. How are we doing? Hope everybody had a good week. Had a phone call there just before the show, so I had to take that one. So I apologize for being a little bit late tonight, but that's how it goes sometimes. I am here, and so are some of you. Thank you for waiting, for those of you that were waiting over here on YouTube. Whew. I want to thank everybody for being here, who has been here and is new here, whatever, however you found me. I'm glad that you're here. Knowledge is power, folks. Without this knowledge, we have no power. So, for those of you that enjoy the channels here and want to help support, pay the bills, keep this stuff going, I would greatly appreciate it. And I thank all those that have. But anything you would like to send, postal money order, regular money order, cashier's checks, regular checks, any gold, silver coinage, anything like that, over to the office through the snail mail is at 6477 West Fairview Avenue, Suite C, Boise, Idaho, 83704. And then, of course, the digital side of things, my PayPal, Kirk_Pendergrass at hotmail.com. And the Cash App is the $ capital K, P, capital PEN 71. And again, those are case sensitive. And then, of course, all my friends over there at Patreon, thank you for the support over there. And having that Wednesday night workshop, we've just kind of been hanging out, discussing a little bit of things here and there, just trying to feel things out. And I've been allowing everybody from every tier to be there. At some point in time, it's going to switch over to just tier 3 and tier 4, and we'll get right into more in-depth stuff and actual relief and remedies and documents and all that good, fun, happy stuff from the rules of the common law and pleadings and practice, how it's supposed to be done, how to effectively defend yourself. So, no further ado. Come on. We're going to go to the older original constitutions or declarations. Now, we've already covered this one here. This is the Pennsylvania. But I brought this one back up for what I have highlighted here, the internal policy of the same. Now, here's the Constitution of North Carolina, a Declaration of Rights. Now, this is December 18th, 1776. Now, you'll notice that this is actually a Declaration of Rights. This is how we lay down the law. Remember, D meaning down, claration, clarify. We clarify with writing the words. This is clarifying the law. Rights as the law. So this is how we lay down the law. Law is that which is laid down, ordained, or established. So here we go. Let's read the law. Why do you think it's first? Just like in over here, this particular one here is a Declaration of Rights of Inhabitants of the Commonwealth or State of Pennsylvania. Then they do the Constitution. Because, see, the Constitution is actually government. It institutes government. But this is the wool being pulled over our eyes that rights are actually the law. And you'll notice here, these are articles. Roman numerals, those are articles. Now, they did articles here for the Constitution as well, but now it says, I see, the Constitution or form of government. So why did they write it separate like this? Because this is laying down the law, and then it institutes government to secure this law. But as we can see here in the Constitution of North Carolina, December 18th, 1776, that all political powers vested in and derived from the people only. Only. Nowhere else. That the people of this state ought to have the sole and exclusive right of regulating the internal government and police thereof. No. Policy. Notice the date, again, pointing this out to make a point. Because we're going to go to etymology and we're going to prove that this word is pronounced policy. There it is. Etymology. (1530s). The regulation and control of a community. Similar in sense to policy. A-E-I-O-U and sometimes Y. From Middle French, policy, organized government, civil administration, late 15th century. From Latin, politia, civil administration. From Greek, polis, city, policy, S. Okay? But not until the mid-19th century. 19th century. Well, let's look at how this changed. And the reason why I'm pointing the date out is because at the time that these declarations of rights and constitutions were written, it was pronounced policy. Because it didn't change what it meant until England changed it. Used in England for civil administration, application, administrative, public order. Public order, not private order. Law enforcement in the community. 1716 is from French, late 17th century, and originally in English referred to France and other foreign nations. The sense of an organized civil force for maintaining order, preventing and detecting crimes, etc., is by 1800. The first force so named in England was the Marine Police, set up in 1798 to protect merchandise at the Port of London. Wow, one of the 3 Tri-City states. Meaning body of officers entrusted with the duty of enforcing laws, detecting crime, etc., is from 1810. They fundamentally changed the word. This is the bar word salad that Chris and I have talked about for years now. They have fundamentally altered that word to expound on their powers and erected a multitude of new offices, sending hither swarms of officers to harass our people and eat out our substance. Bills of attainder, bills of pains and penalty. So, when we get down here, in its most common exception, the policy signifies the administration of the municipal laws and regulations of a city or incorporated town or borough by a corps of administrative or executive officers. with the necessary magistrates for the immediate use of force and compelling obedience and punishing violation of the laws, as distinguished from judicial remedies by action. Ooh, there's a difference there. Primary object of the police system or policy system is the prevention of crime and the pursuit of offenders. But it is also subservient to other purposes, such as the suppression of Mindy and whatever that is, and the preservation of order, the removal of obstructions and nuisances, and the enforcement of those local and general laws which relate to public health, order, safety, and comfort. Century Dictionary, 1895. Now, when we talk about like the 10th Amendment, policing powers, that's policy making powers, because that's what we delegated to the legislature, is to make policy. Because in constitutional law, police power is the power of the government to limit civil liberties and exercise restraint and compulsion over private rights. No, I do not think so. American jurisprudence disagrees. American Jurisprudence, Volume 16, Constitutional Law, Section 2, says that statutes are for government civil conduct. Government conduct. Let's see. Police state regulated by means of national police. We're not supposed to be in a state of being policed under bills of attainder. This goes back to the Declaration for the Causes and Necessity of Taking Up Arms, and why they put no bills of attainder in the Constitution as a limitation. It is strictly prohibited in our form of government. Article 1, Section 9, federal. Article 1, Section 10, state. Bills of attainder are prohibited, which is legislation that prescribes punishment. Gee, wouldn't that be making up a crime? Subjecting us to those pretended acts of legislation? If you do this, that's a crime. And here's the punishment for that. You've been attainted to pay this bill. You owe this debt. It's a punishment. Where's the victim? Oh, we don't have to have a victim. The state's the victim. That doesn't... The state's a fiction, right? We're going to say state of Idaho when we should be saying the territory of Idaho. State regulated by means of national police. First recorded in 1865. Wait a minute. With reference to Austria. Police action in the international sense of military intervention short of war, ostensibly to correct lawlessness, is from 1933. What happened in 1865 and what happened in 1933? Look at this. Police officer is attested from 1794. American English police station is from 1817, and police dog is by 1908. How we've progressed in how we say the word and what it actually means. To watch, guard, or keep order, to govern by policy. Now, I'm going to go to our Idaho Constitution here. Article 11, corporations. Pay attention. Corporations, public and private. Right of eminent domain and policy power reserved. Let's skip to the policy power. And the policy powers of the state shall never be abridged or so construed as to permit corporations. Oh, wait. Because corporations make policy. They don't make law. But they're not supposed to be to allow corporations to conduct their business in such manner as to infringe the equal rights of individuals or the general well-being of the state. Corporations. Remember, the legislature has to make that policy. And they're not supposed to make policy that allows them, right? The police powers of the state shall never be abridged or so construed as to permit corporations. So, in other words, in the law of creating departments, see how we do this, right? Executive department. Departments are supposed to be limited. You're supposed to have a limited form of government. You can only create so much government. We want to keep you in the tiny little blocks that we put you in by constitution, by law. These are the bylaws of the territory of Idaho. All executive and administrative officers, agencies, and the instrumentalities of the executive department of the state and their respective functions, powers, and duties, except for the office of governor, lieutenant governor. Wait a minute. These are departments. Each one of these is a department. So let's pay attention to what a department looks like. So we know what we're creating looks like these. And these are all elected officials, right? Secretary of State, State Controller, State Treasurer, Attorney General, and Superintendent of Public Instruction shall be allocated by law, policy, corporate bylaws among and within not more than 20 departments by no later than January 1st, 1975. So, now that we know our limited form of government and what they can create is 20 departments, and that's it. They can't continue to go down the road and just create all these other things. Oh, but wait. Temporary agencies may be established by law and need not be allocated within a department. However, such temporary agencies may not exist for longer than 2 years. Where did they get that concept? I wonder where we got that from. To raise and support armies, but no appropriation of money to that use shall be for longer than a term than 2 years. That's a fundamental principle of our form of government. But then you're creating it outside of the limitation of the 20 departments. It's a contradiction. Oh, for emergency. Temporary agencies, pardon me. Subsequently, all new powers or functions shall be assigned to departments. What do you mean, all new powers? What do you mean, new powers? That's assuming powers. Shall be assigned to departments, divisions, sections, or units in such a manner as will tend to provide an orderly arrangement in the administrative organization of state government. Now, administrative. What did we just read? Administration. The regulation and control of a community. Imagine that, folks. Who is that to control? It controls that which it has created. So we give certain powers to the legislature to create departments. They have to create the policy or the public law to create it. It's the law of creation. But who created government? The people did. So fundamentally and principally, those that sit in those emoluments that were created by the people, by law, by constitution, has to come from them. And if it's not delegated, it doesn't exist. And then again, we go back to the rule of law, maxim of law. What I cannot do in my person, I cannot do through the agency of another. So if I can't do it, no, has all political powers vested in and derived from the people only. It doesn't come from a foreign emolument. Those are strictly prohibited in our form of republican form of government here. Can't have that. That's an assumed power. It's an usurpation of power. The people of state ought to have the sole and exclusive right of regulating the internal government and policy thereof. If we were to say that the people of this state ought to have the sole and exclusive right of regulating the internal government and police thereof, that doesn't make sense. We're talking internal. Now, here it is. That no man or set of men are entitled to exclusive or separate emoluments or privileges from the community, but in consideration of public services. Community. The regulation and control of a community is policy. Rights are the law. Look at what we're reading here. That the legislative, executive, and supreme judicial powers of government ought to be forever separate and distinct from each other. That all powers of this is a good one. That all powers of suspending laws or the execution of laws by any authority without consent of the representatives of the people is injurious to their rights and ought not be exercised. That's one of those rights to a republican form of government, so that we don't have governors declaring a natural disaster and a state of emergency and shutting down businesses and doing whatever. That's what they're talking about right there. That all powers of suspending laws, rights as the law, or the execution of laws by any authority without consent of the legislature, representatives of the people, is injurious to their rights and ought not be exercised. That election of members to serve as representatives in General Assembly ought to be free. In all criminal prosecutions, every man hath the right to be informed of the accusation against him and to confront the accusers and witnesses with other testimony, and shall not be compelled to give evidence against himself. So when they do a request for discovery from the defendant, what do you mean? Why are you requesting discovery from the defendant when you're the plaintiff? You're already supposed to have all the evidence. Burden of proof's on the moving party. What evidence do you have? I don't have to give you jack. I don't know who you think you are, but you don't have any power to demand from me evidence. Okay. That no free man shall be put to answer any criminal charge but by indictment, presentment, or impeachment. This is where they're saying not by information under a bill of attainder. What that means, that no free man shall be convicted of any crime, but by the unanimous verdict of a jury of good and lawful men in open court as heretofore used. Again, it's got to be unanimous consent of all 12 men. There is no such thing as a hung jury. It's a lie. That's more the bar schmew word salad. It's the reason why we have the right to poll the jury. And each man has to stand up and say either guilty or not guilty. And if there's one of them that says not guilty, that's done. That's not unanimous. But for those of you that are getting active and demanding your right to a trial by jury and, defending yourself out there, you get to write your jury instructions and make sure that you write in your jury instructions that you're instructing the jury about this, that it must be unanimous consent of finding of guilt. And then if there's one of you who does not think that I'm guilty, you can say not guilty. But see, I've been through this. I've read their jury instructions, and I didn't realize that I actually had the power to write my own jury instructions. And this is also where we do judicial notice to the jury. Facts of law. Whoops. So, these are things you're going to need to learn to defeat these people and all of their corruption. You're going to have to take control of your own case. That excessive bail should not be required, no excessive fines imposed, no cruel or unusual punishments inflicted. That's the other thing, is the jury is the one that's supposed to decide that. That general warrants whereby an officer or messenger may be commanded to search suspected places without evidence of the fact committed, or to seize any person or persons not named whose offenses are not particularly described and supported by evidence, are dangerous to liberty and ought not to be granted. That no free man ought to be taken, imprisoned, or disseized of his freehold liberties or privileges, or outlawed or exiled, or in any manner destroyed, or deprived of his life, liberty, or property, but by the law of the land, not policy, not bylaws, the common law. That every free man restrained of his liberty is entitled to a remedy, to inquire into the lawfulness thereof, and to remove the same, if unlawful, and that such remedy ought not be denied or delayed. That's the Magna Carta, 1215, chapter 40. To no man will we sell, to no man will we deny rights or justice or right. That's what that is. That's where that came from. And so when we're talking about to inquire into the lawfulness thereof, and to remove the same. Anything that was unlawfully done, it's not lawful. It's void for any effect. It's fraud, because fraud vitiates everything from its inception. Void ab initio. Void for any effect. Can't use it. That in all controversies at law respecting property, the ancient mode of trial by jury is one of the best securities of the rights of the people and ought to remain sacred and inviolable. Hello? That the freedom of the press is one of the great bulwarks of liberty, and therefore ought never to be restrained. Never. Not by any rule making. Craig Cheney from August 25th, 2020. When you said those people couldn't sit there in the general public seating area because they didn't have your permission as media to sit there. It's a bulwark of liberty. It shall never be restrained. That the people of the state ought not to be taxed or made subject to the payment of any impost or duty without the consent of themselves or their representatives in General Assembly freely given. Now remember, you still have free inhabitants. But anyways, that the people have a right to bear arms for the defense of the state, and as standing armies in times of peace are dangerous to liberty, they ought not to be kept up, and that the military should be kept under strict subordination to and governed by the civil power. Where does it say police force? It says military and no standing armies. None. That the people have a right to assemble together, to consult for their common good, to instruct their representatives, and to apply to the legislature for the redress of grievances. Imagine that again. Legislature, legislature, legislature. That all men have a natural and unalienable right to worship Almighty God according to the dictates of their own consciences. Liberty of conscience is what religion is about. That for redress of grievances and for amending and strengthening the laws, elections ought to be often held. That a frequent reoccurrence to fundamental principles is absolutely necessary to preserve the blessings of liberty. This is what we're doing right here tonight, folks. Isn't this fun? We're frequenting those fundamental principles that is absolutely necessary. This is the power. This is the knowledge. Them fundamental principles. Right here. To preserve the blessings of liberty from Almighty God. Liberty of conscience being one of them. So the frequent recurrence to them fundamental principles is what we need to get back to. That no hereditary emoluments, privileges, or honors ought to be granted or conferred in this state. That perpetuities and monopolies are contrary to the genius of a free state and ought not to be allowed. Now, all you bar members out there, maybe one of y'all can answer this question. Can any man retain assistance of counsel for someone, from someone other than a member of the bar? Because if the answer to that is no, because that would be unlicensed practice of law, you have to be a member of the bar to practice law, then that creates a monopoly, doesn't it? And the government can't create monopolies. And that's what they did, because the American Bar Association wasn't created until 1887. Or was it 1878? 1878? Oh, well, let me log in. I ain't got no fuck. I ain't got no freaking login. Oh, okay. August 21st, 1878. Founded is a voluntary bar association of lawyers and law students, which is not specific to da. Really? It's a volunteer association? Voluntary. So if it's voluntary, that means not everybody has to go there. But then, again, answer the question. If perpetuities and monopolies are contrary to the genius of a free state, not to be allowed, how did we create that? And again, the ultimate question, the multi-million-dollar question here is there anyone else that we can have as assistants of counsel other than a member of the bar? They don't like it. But I can tell you right now, like in Tony Pellegrino's case there down here in Idaho, the first time we went down there, nope, you got to have a license to practice law on the state of Idaho. I'm like, there is no license. But hey, I'm with E-Clause, and I'm telling you, we already went to Congress. There is no license to practice law. Well, you got Idaho, but okay. So we filed the practitioner judicial report. When we come back to go for trial by jury here, Tony asked if he could have his assistants of counsel up there again after we filed the practitioner's judicial report and after we did the objection to the motion in limine about this, the prosecutor making the claims that trying to limit Tony because he was making sovereign citizen and constitutionalist arguments, and can't allow him to make those arguments to the jury. And boy, did I hammer out a response for that. And did they want to take it up? No. As soon as the judge said, well, we got a motion in limine here. Do we need to take that up? Prosecutor's like, no, never mind. Nope. Because I demanded proof of everything that he asserted and claimed. And then the thing is, some people out there, oh, you can't do that. Really? Well, why is it that all of a sudden the judge said when Tony asked if he could have his assistants of counsel up there for the trial, and the judge is like, yeah, sure, come right on up. There was no, oh, you got to have a license to practice law. What happened to that? Went right out the window with the practitioner's judicial report, didn't it? We exposed them as a monopoly. You can't license the practice of law. Your membership card to the bar association is not a license. His licenses come from the executive branch, not the judicial, and not an association. Question for all you people out there that think that we got to have a license to practice law. Okay. From the Idaho State Bar Association or the American Bar Association, Well, what about the National Rifle Association? Do they have the power to issue licenses? I mean, if we're going to say that the Idaho State Bar Association, you have to go get your membership card and that's the license to practice law. Okay, fine. Then any old association can hand out licenses. I mean, we're establishing a principle here, and that principle has to apply equally to all. It can't just be one way on one thing and not apply equally elsewhere. So the answer is no. The National Rifle Association has no authority to issue licenses for anything. This is also what Chris put in the Practitioner Judicial Report, is the Texas Constitution, which says pretty much exactly the same thing, that perpetuities and monopolies are contrary to the genius of a free state, not to be allowed. It's quite amazing how some of this has made it through. And again, remember, this is a right. This is the law. This isn't the Constitution. This is the rights. This is the right to a Republican form of government. These are like preemptions, limitations that they just do not want us to know about. But see, I truly believe that we need to return to these fundamental principles, our rights, the law. So that's why I'm here. Yep. That I am. You going after the bar, bro? Miss you, Chris. That retrospective laws punishing facts committed before the existence of such laws and by them only declared criminal are oppressive, unjust, and incompatible with liberty. Wherefore, no ex post facto law ought to be made. Boy, this one looks like a good one. The property of the soil in a free government being one of the essential rights of the collective body of the people, it is necessary in order to avoid future disputes that the limits of the state should be ascertained with precision. And as the former temporary line between North and South Carolina was confirmed and extended by commissioners appointed by the legislatures of the two states, agreed to the order of the late King George II in council, that line, and that only, should be esteemed the southern boundary of this state as follows. That is to say, being on the seaside at the Cedar Stake or at the near the mouth of, see how they described the boundaries? Therefore, all the territories, seas, waters, and harbors, with their apparent and a line between the line above described and the southern line of the state of Virginia, which begins on the seashore in 36 degrees 30 minutes north latitude, and from thence runs west, agreeable to the said charter of King Charles, are the right and property of the people of this state, to be held by them in sovereignty. And any partial line without the consent of the legislature of the state at any time thereafter directed or laid out in any wise notwithstanding, provided always that this declaration of rights shall not prejudice any nation or nations of Indians from enjoying such hunting grounds as may have been or hereinafter shall be secured to them by any former or future legislation of this state. Wow. Kind of seems like they were kind of helping defend the Indians too, weren't they? Oh no, but we didn't have that back then. They were all bad. I got news for you. There's a whole lot different picture to be painted here about the Indians and what happened. And provided also that it shall not be construed so as to prevent the establishment of one or more governments westward of this state by consent of the legislature, and provided further that nothing herein contained shall affect the titles or repossessions of individuals holding or claiming under the laws hereto in force or grants heretofore made by the late King George II or his predecessors or the late lords proprietors or any of them. So, now getting into the Constitution part. Allegiance and protection are, in their nature, reciprocal, and the one should of right be refused when the other is withdrawn. So, what it's saying here is, whereas allegiance and protection are, in their nature, reciprocal. Okay, we instituted government for our protection, right? And the other should, the one should of right. So, in other words, we have a right here. And this is the Constitution telling government that we have the right to refuse when the other is withdrawn. Our allegiance to the government, to our state of being free and equal, when they fail to protect us, we have the right to refuse to obey them. I'm just curious. Let's see, is Admiralty in here? Nope, not really talking about Admiralty jurisdiction. As is back to that Pennsylvania. Again, that are frequent reoccurrence to fundamental principles and a firm adherence to justice, moderation, temperance, industry, and frugality are absolutely necessary to preserve the blessings of liberty. It's quite the thing that everybody thought that way back then, right? That the people have a right to bear arms for the defense of themselves and the state. And as standing armies in the time of peace are dangerous to liberty, they ought not to be kept up, and that the military should be kept under strict subordination to and governed by the civil power. So, again, these are, rights, the law. And there it is in a better explanation than the Second Amendment. And because it is a right, it's off limits to government. We're telling them that the people have this right to bear arms for the defense of themselves and the state. That's why it says a militia being necessary for the security of a free state of being free and equal and having liberty of conscience here, we have the right to keep and bear arms, and that right shall not be infringed. There's no subject matter jurisdiction. This is a right. It's the law. This is the fundamental law that's off limits to government. Hmm. But here's the thing: is it's in here talking about internal policy of the same policy, internal policy. And this is before they changed the word from policy to police. And here's the evidence of it. Because again, this is the Pennsylvania, September 28, 1776. They didn't change it. In England till 1798, and essentially not until 1865, until mid 19th century, which is 1865. Now, 1861 to 1865 was the Civil War, was it not? Got to know your history here to see why these dates, timelines have meaning. And then in 1933 is when they took the gold. They had to send in these police officers to come seize the gold because they couldn't send the military in. So they had to get these armed bodies of men, these standing armies, to do their dirty work. So what else we got here? Oh, wait. That was North Carolina there. How about we look at let's look at Delaware. See, the government of the counties of Newcastle, Kent, and Sussex upon Delaware, said representative be chosen by the freemen of the said state of the express purpose. They don't really have a Bill of Rights. Oh, here's a good one. Article 15, the sheriffs and coroners of the respective counties shall be chosen annually. As heretofore, any person having served 3 years as sheriff shall be ineligible for 3 years after. And the president and privy council shall have the appointment of such of the two candidates returned for said offices of sheriff and coroner, as they shall think best qualified in the same manner that the governor heretofore enjoyed this power. Why aren't they talking about a police force or a police officer? And this is what I keep saying, the sheriff and his one deputy. See, the sheriff's the one you call for the ones that got away. The coroner's the one you call for the ones that didn't. It's the way it was back then. We had the right to keep and bear arms to defend ourselves and the state at any time we deemed it necessary. This is why we didn't allow armed bodies of men. So they couldn't come in and bully us around like they're doing today. Oh, what's that? Article 25. The common law of England, as well as so much of the statute law, has been heretofore adopted in practice in this state, shall remain in force unless they shall be altered by a future law of the legislature. Such parts only accepted as are repugnant to the rights and privileges contained in this Constitution and the Declaration of Rights is agreed to by this convention. Huh. Wonder where the Bill of Rights is. Oh, the Continental Congress. Uh-huh. That would be the Virginia Declaration of Rights. As the theoretical foundation of all government. Huh. Oh, this one was assembled at Newcastle with the recommendation of the Continental Congress that the people of the colonies should form independent state governments. It was not submitted to the people, but was proclaimed September 21st, 1776. That's how they had to do it back then, right? Because they weren't officially formed into a independent sovereign state of being, free and equal, free from tyrants. But see, the Continental Congress is the one that told everyone to do a convention in each of the states. But see, the Virginia Declaration of Rights was June 12th, 1776. So that was Delaware. What about Georgia? Let's see what Georgia was like. 1777. Whereas the conduct of the legislature of Great Britain for many years past has been so oppressive on the people of America that of late years they have plainly declared and asserted a right to raise taxes upon the people of America and to make laws to bind them in all cases whatsoever without their consent, which conduct being repugnant to the common rights of mankind, the common rights, common law, have obliged the Americans as freemen to oppose such oppressive measures and to assert the rights and privileges they are entitled to by the laws of nature and reason. And accordingly, it hath been done by the general consent of all the people of the states of New Hampshire, Massachusetts Bay, Rhode Island, Connecticut, New York, New Jersey, Pennsylvania, the counties of Newcastle, Kent, Sussex, and Delaware, which we just looked at, Maryland, Virginia, North Carolina, South Carolina, and Georgia, given by their representatives, met together in General Congress in the city of Philadelphia. Huh. And whereas it hath been recommended by said Congress on the 15th of May last, the respective assemblies and conventions of the United States were no government sufficient to the exigencies of the affairs, hath been hitherto established to adopt such government as may, in the opinion of the representatives of the people, best conduce to the happiness and safety of their constituents in particular and America in general. Independence of the United States of America has been also declared on the 4th day of July, 1776, by the said honorable Congress, and all political connection between them and the crown of Great Britain is in consequence thereof dissolved. There it is again. We therefore, the representatives of the people from whom all power originates and for whose benefit all government is intended, by virtue of the power delegated to us, do ordain and declare. And it is hereby ordained and declared. Reset it again to make sure that, and it is hereby ordained and declared, that the following rules and regulations be adopted for the future government of this state. The legislative and judicial departments shall be separate and distinct, so that neither exercise the powers properly belonging to the other. Imagine that. Oh, but remember when Attorney General Barr was speaking out there and he was saying that, oh, well, we didn't quite have it right yet. Well, this is 1777. It's laying down 3 distinct branches of government and separate from each other. Whoops. Some of my followers might remember my comments on that when I showed that video. The legislature of the state shall be composed of the representative of the people, and is hereinafter pointed out that the representatives shall be elected yearly and every year on the first Tuesday in December, and the representatives so elected shall meet in the first Tuesday of January following at Savannah or any other place or places where the House of Assembly for the time being shall direct. Oh, let's see. There shall be an unalterable rule. So here it shall be an unalterable rule that the House of Assembly shall expire and be at an end yearly and every year on the day preceding the day of election mentioned in the foregoing rule. So in other words, they were there every day, all year long, right up into the day preceding the day of election. They're splitting it up, how it's all works. There are counties and representatives from each of those counties or towns. County shall be another county. They're creating the counties, right? See, the House of Assembly shall have power to make such laws and regulations as may be conducive to the good order and well-being of the state, provided such laws and regulations be not repugnant to the true intent and meaning of any rule or regulation contained in this Constitution. The House of Assembly shall also have power to repeal all laws and ordinances they find injurious to the people. And the House shall choose its own speaker, appoint its own officers, settle its own rules of proceeding, and direct writs of election for supplying intermediate vacancies, and shall have power to adjournment to any time or times within the year. All laws and ordinances shall be 3 times read. We still have that on the books today. And each reading shall be on different and separate days, except in cases of great necessity and danger, And all laws and ordinances shall be sent to the Executive Council after the second reading for their perusal and advice. All male white inhabitants of the age of 21 years and possessed in his own right of 10 pounds value and liable to pay tax in this state, or being of any mechanic trade, and shall have been resident 6 months in the state, shall have the right to vote at all elections for representatives or any other officers herein agreed to be chosen by the people at large, and every person having a right to vote at any election shall vote by ballot personally. Huh. No person shall be entitled to more than one vote, which shall be given in the county where such person resides, except as before excepted, nor shall any person who holds any title of nobility lie entitled to vote, or be capable of serving as a representative, or hold any post of honor, profit, or trust in this state, while such person claims his title of nobility. Boy, this is a good one. But if the person shall give up such distinction, in the manner as may be directed by any future legislation, then in such case he shall be entitled to a vote and represent as before directed, and enjoy all other benefits of free citizen. So, this was at a time where they recognized them barristers, members of the Crown Temple Bar, holding the title of nobility of Esquire. You can't vote. You can't run for office, hold any post of honor, profit, or trust in this state, or be capable of serving as a representative. Huh. Remember, this is the Georgia one, right? So I'll have to remember that one. Georgia, 1777. Oh, every person absenting himself from an election and shall neglect to give his or their ballot at such election shall be subject to a penalty not exceeding £5. The mode of recovery and also the appropriation thereof to be pointed out and directed by act of the legislature, provided nevertheless the reasonable excuse shall be admitted. Now, notice what they're talking about. £5. Remember fixing the weights and measures? £5 of what? Gold. Or was it? Nah, I guess that would actually probably be £5 of English doll hairs, because that was English back then. So I stand corrected. Whatever that converts into these days, but I forgot that the English pound. Oh boy. Yeah, all right. Okay, so comment out on Facebook, laughing out loud, male. And what about us? Female power taken even back then? No, it wasn't taken. It just didn't have it. See, the way the Bible talks about things, the woman is supposed to be the keeper of the house, run the household. Okay. Women weren't supposed to be in positions of emoluments. I'll leave that right there. Other than that, that's the way it was, right? See, that didn't change. That was the women's rights things Finally, women got the right to vote, which also led to the right to hold public office. And then all shit went to hell in a handbasket. So, anyways, I truly believe that that the woman is actually supposed to be the counterbalance, the counterpart in a marriage, and is there to be a sounding board to give advice and to bounce things off of, right? So I truly believe there is a part uh, to play in a marriage in the household. I personally don't really think women should be in government. I don't think we should have them in there. But all I can say is today, I'm seeing more women standing up and kicking ass out there than I see men. So, on that note, go women. I don't know what the heck's going on, but let's do it anyways. You want the right to vote, not to work. But, um, well, I guess that's possible, right? I do believe the Bible was manipulated, but not the whole entire thing. Come on now. But we're in a way, way far down the road in time. And like I just said, uh, I'm I'm seeing more women out there standing up like they've got a pair better than most men. I don't know what the heck's going on out there. Well, kind of have an idea with vaccines and drugs and all that stuff messing up our boys, men. But yeah. But see how this was all set up back then is about by ballot. And you had to have a certain status, and you couldn't have a certain status of a title of nobility to run for office or even to vote. But I want to go back up that. Where is that? Yeah. All male white inhabitants, not female. Wanted to wanted to reiterate that it was male, not man and woman, which just reiterates that we only have two genders, right? We have a man and a man with a womb. That's woo man. Or as I like to call it, they come with their own warning label. Whoa, man. Pay attention. You've been warned. Just saying. It is Friday. Gotta have a little fun, right? That's my that's my joke. And it is just a joke. Let's see. What did I do? I messed myself up here. Where's them no titles of nobility at? I'll remember that. What the heck? Okay, there it is. No title of nobility. Right there. So it's very clear here that they knew about them titles of nobility. They didn't want them in government. They didn't want them to be their representatives. They didn't want them to be able to vote. They didn't want them to hold any office of public trust. Right there. Post of honor, profit, or trust under in this state. Imagine that. Emolument, any advantage, profit, or gain received due to one's position of employment or holding of office. They didn't want them guys in there that had any title of nobility. Trust me, I'm pretty sure, based on my studies and research, is they figured it out. That this is the reason why they assembled in a constitutional convention to do the Article the 13th. Now, see, this is another one of those instances where I pose the question to people and members of the bar out there that don't think this is true. Why is it that Congress had to have a constitutional convention and make an amendment, an Article the 13th, that basically says what it says right here, that no titles of nobility. You cease to be a citizen of the United States and you can no longer hold any office of public trust. Da, 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 da. Why did they have to go through a constitutional convention and have it ratified by the states if that's not how we're supposed to make law? Because think about it. If Congress has the authority to make law through a legislative act without going through a constitutional convention, so why is that? Why back in 1809 did they have to go into a constitutional convention when they could have just made a code, could have made a statute? Would have been just easier, right? But that's, in my mind, prima facie evidence of how we're supposed to make law. The rest of it is policy. And it only applies to the corporations that the legislature creates and the agents that are under contract of employment. Any post of honor, profit, or trust in this state. Good one. February 18th, 13 women in Syracuse, New York register and vote, the first time women had legally voted in the state since 1777. Wonder what the actual date that was. February 18th, what? 1777? But that was, New York. I don't think New York was around back then. Oh, yeah. It's nice to read some of these older oaths of office they used to require. I do solemnly swear that I will bear true allegiance to the state of Georgia and will truly perform the trusts reposed in me, and that I will execute the same to the best of my knowledge for the benefit of the state and the support of the Constitution thereof, and that I have obtained my election without fraud or bribe, whatever. So help me God. Why did we get away from that verbiage? Especially the so help me God. Whoa. Every person entitled to vote shall take the following oath or affirmation if required. I do voluntarily and solemnly swear or affirm, as the case may be, that I do owe true allegiance to this state and will support the Constitution thereof. So help me God. That's just to vote. But see, that's again, this is that clear indication that there is that's the clear distinction um, between a free inhabitant and one of the people. Oh, let's see. No person bearing any post or prominent understanding person bearing any military commission except the militia shall be elected. By this article, it is not to be understood that the office of a justice of the peace. In other words, they're not supposed to be making any profits or gains by being a justice of the peace. Huh, how about that? No person shall hold more than one office of profit under this state at one and the same time. That's right. You can't be on the clock in two different places at the same time. It's literally impossible. You can't be on the clock at McDonald's and then be on the clock at Burger King at the same time. It's literally impossible without fraud or a clone or some hologram. Of course, I don't know how many holograms can actually, flip a burger and make some French fries. But, the thing is here is it should be common sense. But the fact that they put it in here that you can't hold more than one office at a time, why did they do that? Because that was part of the problem back then, as you'd have a justice of the peace doing one thing and also another. And I'm like, no, we're not going to have that. We're going to make sure that doesn't happen in our Republican form of government. The governor shall, with the advice of the executive council, exercise the executive powers of government according to the laws of this state and the constitution thereof, save only in the case of pardons and remissions of fines, which he shall in no instance grant, but he may reprieve a criminal or suspend a fine until the meeting of the assembly, who may determine therein as they shall judge fit. Whoa. Why is that not going to the judicial branch? Why is that going to the legislature? See, even back then, that's the way it was, wasn't it? Uh-oh. Here's one that's so apropos today. The governor, with the advice of the executive council, shall have power to call the House of Assembly together upon any emergency before the time which they stand adjourned to. Uh-oh. That's because the executive branch can't do that, right? That was one of those other ones in there, and I don't know if it's in here, but what is it? Right here. that all powers of suspending laws or execution of laws by any authority without consent of the representatives of the people is injurious to their rights and ought not to be exercised. That's kind of what they're talking about here. That the governor, with the advice of the executive council, shall have power to call the House of Assembly together upon any emergency before the time which they stand adjourned to. So when there is some sort of an emergency, it has to be done by consent of the legislature, and then that has to open it up for the people to come in there and remonstrate and address and ensure justice and make sure that they're only acting in such a manner that they're not depriving people of their fundamental rights. Because they can't do that to begin with, that they actually deal with the emergency. The governor, with the advice of the executive council, shall fill up all intermediate vacancies. It shall happen. Mm. The governor, for the time being, shall be captains general and commander in chief over all the militia and other military and naval forces belonging to this state. Where is it? Why isn't it talking about a police force? All militia commissions shall specify that the person commissioned shall continue during good behavior. But see, why aren't they saying that the governor should be over the police? Because police didn't exist then. Policy. I mean, let's just see. Is it even in here? 0. The word police or policy is not even in this document at all. Not even once. Why is that? Because that's not what it meant back then. It got changed through time. That was Georgia. Let's take a look at Maryland. Imagine that all government of right originates from the people, is founded in compact only, and instituted solely for the good of the whole. The people of the state ought to have the sole and exclusive right of regulating the internal government and policy thereof. There it is again. This is the all political powers inherent in the people, and we have the right to alter, reform, or abolish anything at any time we deem it necessary. But see, these guys knew back then that it was policy. It hadn't even been pronounced police, or however you want to say it. Now that I know, it's like I can't even hardly say it police. It's policy. The inhabitants of Maryland are entitled to the common law of England and the trial by jury according to that law, and to the benefit of such of the English statutes as existed at the time of their first immigration, and which by experience have been found applicable to their local and other circumstances, and of such others has been since made in England or Great Britain, and have been introduced, used, and practiced by the courts of law or equity, and also to acts of assembly in force on the 1st of June 1717 for, except as may have since expired, or have been or may be altered by facts of convention, or this declaration of rights, subject, nevertheless, to the revision of an amendment or repeal by the legislature of this state. And the inhabitants of Maryland are also entitled to all property derived to them from or under the charter granted by His Majesty Charles I to Crecilius Calvert, Baron of Baltimore. So see, they're talking about free inhabitants now. Same thing with the Articles of Confederation, the free inhabitants. I mean, who are these set of people, set of men? Is there a difference between a free inhabitant and a people? There is, isn't there? That all persons invested with the legislative or executive powers of government are the trustees of the public. Now, that all persons invested with legislative or executive powers, see, these are the citizens when they're vested with power of government that the people create. And it's are the trustees of the public. That's why it's policy, public law. I don't know when it changed from policy to public law. I haven't figured out that one yet. But that's the trickery. Oh, well, it's public law. Well, who are the public? That would be them persons invested with powers of government, are public servants. That's those persons. See? Because when we're talking about person, we're talking about in their proper person, in propria persona. And instead of calling these titles of nobility, such as governor, lieutenant governor, secretary of state, we didn't call them titles of nobility, but they were still in their proper person. No, New York wasn't around. Nope. Mm-mm. Let's see. So that's, this isn't word salad though. This is the thing. Why they use the word persons is because, again, in propria persona, in their proper person, in that trustee, in that position. Bingo, Mark's got it. Person, citizen, public, the people, sovereign, private. I mean, that's short, sweet, clear, concise statements of fact right there. That's it. You can't get it any more simple than that other than add man. Private. So, I mean, that's just kind of what it says. And I actually discovered this in reading when it said in their proper person, and it was talking about the Prince of Orange. I'm like, oh, that's in proprietary. Okay, I get it. So, This is how I figured these out based on the writings, the actual documents. Again, reading means reading, but we try to play around with person this and person that and blah, 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 blah. Well, when we get into the Latin, in propria persona, and your proper person, proper being the trustee in that position of emolument, that's citizen. And citizen is actually defined. Well, this is going to be a fun one real quick. Well, I doubt it'll be quick. Come on. Nope. Don't have it in there. Not in my list. It would be in The Law of Nations, written by Emer D. Vattel. There it is. There we go. Book 1, chapter 19. Book 1, chapter 19, section 212. Oh, wait a minute. Oh, I got to go down here. Of our native country and several things that relate to it. What is our country? The whole of the countries possessed by a nation and subject to its laws. Forms, as we have already said, its territory. So the territory of Idaho is a country. It's just the way it is. It's not a state. State is about a state of being, the body politic, the Constitution, the law. Our rights is the law, declarations of rights. That's the body politic and our state of being governed. Okay. And is the common country of all the individuals of the nation. See, we have nation, America, Idaho, Montana, Washington. They're all countries. You spin the map or globe around and you look at all these other nations and they list them as countries. Why are they not countries over here? Oh, because they're the United States of America. Oh, okay. Yeah. A United States of being under Christianity, whether you wanted to be Protestant, Catholic, whatever, that's the states of being. But nonetheless, as it says right here, it's territory. The territory is the country. That's why, well, where were you born? I was born in California. I was born in Idaho. I was born in New York or whatever. That's your country. Born, not birthed. Ships are birthed. Just saying. Oh, you guys can't see this. I just noticed that. All right. Now you can see what I'm reading from. Sorry about that, folks. So, again, this is The Law of Nations, written by Emmer D. Vattel, Book 1, Chapter 19. I'm reading from section 211. But I was talking about citizens. Who are the citizens? Persons in their proper person, impropriety persona. The citizens are the members of the civil society, bound to this society by certain duties and subject to its authority. They equally participate in its advantages. The natives or natural born citizens are those born in the country of parents who are citizens. Okay. This is also the part where we talk about in the Constitution where it says the president has to be a natural born citizen. This is where it's cited from. Right here. The Law of Nations, written by Emmer D. Vattel. And anytime that it's talked about out there, this is where the source is cited from. Because this is international law and it applies to all nations. It is the law of nations. So, to fully comprehend some serious law, this book was a very good read because our founders used this book and they were very well aware of this books. There's actually 3 books. But as we can see right here, citizens are the members. Members are like, I don't know. What about a member of the bar? What about the members of a gym membership? What about of a library? You have a membership card. Like Chris and I used to joke about, hey, my library card's got a higher standing than your bar card does. At least it's legitimate. Okay. But that's what a member of the civil society, government, civil administration. Bound is the key word. Bound to this society by certain duties. Article 6, Clause 3 requires everyone from the legislative branch, executive branch, and judicial branch to be bound by oath or affirmation. We were just reading some of them oaths or affirmation. Those are the citizens. Now, the real question, are you a natural born citizen? Were your parents? And more specifically, when it talks about natural born citizens, are those born in the country of parents who are citizens, as the society cannot exist and perpetuate itself otherwise than by the children of the citizens. Those children naturally follow the condition of their fathers. Hate to be the bearer of bad news. They follow the condition of their fathers and succeed to all their rights. The society is supposed to desire this in consequence of what it owes to its own preservation. And it is presumed, as a matter of course, that each citizen, on entering into society, reserves to his children the right of becoming members of it. The country of the fathers is therefore that of the children. And these become true citizens merely by their tacit consent. Imagine that. We shall soon see whether on their coming to the years of discretion, of lawful age, they may renounce their right and what they owe to the society in which they were born. I say that in order to be of the country, it is necessary that a person be born of a father who is a citizen. For if he is born there of a foreigner, it will be only the place of his birth. I don't know why. I guess, anyways, and not his country. Maybe they just twisted the words since then. It's not like I haven't showed enough evidence of that tonight, of twisting words. So right here. So let's say somebody from Africa comes over here and they have a baby here. That's just the place of the birth where they're born. They're actually from the country of their father. They follow the conditions of the father. So if the father is from Africa, like, I don't know, maybe Kenya, that means his son would be from the country of Africa, and therefore is not a natural born citizen. And therefore the Constitution dictates that he cannot run for president. Y'all picking up what I'm laying down right there? On Barry's birth certificate, the one that they got a hold of that wasn't altered, said his father was from Kenya, which means Barry is not a natural born citizen, which means he can't run for president. He can't be president. But how was he? Now, let's look at the next one. Section 213, inhabitants. The inhabitants, as distinguished from citizens, are foreigners who are permitted to settle and stay in the country. Bound to the society by their residence, they are subject to the laws of the state which they reside in it, and they are obliged to defend it because it grants them protection, though they do not participate in all the rights of citizens. They enjoy only the advantages which the law or custom gives them. Now, let me finish that, and then we'll show you again why we need to comprehend what's actually being said here and what the law actually is. The perpetual inhabitants are those who have received the right of perpetual residence. These are a kind of citizens of an inferior order and are united to the society without participating in all of its advantages. Their children follow the condition of their fathers, and as the state has been given to these the right of perpetual residence, their right passes to their posterity. So our founders looked at this and said, we're going to go with people here. There's a clear distinction between the people and a citizen. The citizens are those who are employed, that sit in those seats in government or are elected, right? The people retain their sovereignty because at this particular point in time, our republic did not exist. Our form of government did not exist. So they took this into consideration in how they created our form of government. And basically they said that the people were those with mechanic trades, were the tradesmen. And the tradesmen made the policy regarding other tradesmen by contract or compact, the policy. That would be what we look at as the statutes today, policy. that all blacksmiths had to have this code of conduct, that all horsemen had this code of conduct, and that policy only applied to them. It didn't apply to a blacksmith. Or the general laws did, was general to all of the blacksmiths and all the horsemen and all of the tenders and farmers and all of that. That was the general policy, which they became the people, having the right to vote, which is what I was just showing there in the Georgia, the Pennsylvania Constitution. Who had the right to vote? And this is what they're talking about here as a resident. Now, this has all been twisted, but yet here it is from the root of law of the nations. But it says the inhabitants, as is distinguished from citizens, are foreigners. What are they foreign to? In this sense, they're foreign to the policy, the public law, the government. I go right back to Hale versus Henkel. Oh, I need to see the case. I don't know if I can make that smaller. There we go. This is such a powerful case. The verbiage that says the things that are talked about in here. Like an opinion that an officer of a corporation which is charged with a violation of a statute of the state of its creation or of an act of Congress passed in the exercise of its constitutional powers cannot refuse to produce the books and papers of such corporation. We do not wish to be understood as holding that a corporation is not entitled to immunity under the Fourth Amendment against unreasonable searches and seizures. A corporation is, after all, but an association of individuals under an assumed name and with a distinct legal entity. Association? Here's another spot. It is true that the corporation in this case was chartered under the laws of New Jersey and that it receives its franchise from the legislature of that state. A corporation is created, the corporate charter, franchise, by the legislature. Like I was just explaining, it applies to certain corporations. It does not have the force and effect of law on the people in the private. If you're in the public, in service, a corporation providing goods and services in interstate and foreign commerce, this is why we require them to have a business license and incorporate into the body politic exactly what we were just talking about right there. Bound to the society by their residence, they are subject to the laws of the state while they reside in it, and they are obliged to defend it because it grants them protection, that they do not participate in all the rights of citizens, such as to run for office or hold office of public trust. They enjoy only the advantages of the law or customs give them. The perpetual inhabitants are those who receive the right of perpetual residence. Okay. Now we go back. Now, this particular spot right here. Uh-oh. Where did it go? Yeah, there we go. Page 201, US 74. This is Hale versus Henkel, 1906. If you got to catch this word here. This is saying if you guys don't see this, it's showing that you do. If whenever an officer or employee of a corporation were summoned before a grand jury as a witness, he could refuse to produce the books and documents of such corporation upon the ground that they would incriminate the corporation itself. It would result in the failure of a large number of cases where the illegal combination was determinable only upon the examination of such papers. So that's the if. And they're saying, yeah, if we were to allow that, then we would never get anywhere. But conceding that the witness was an officer of the corporation under investigation, because that's the power belonging to the people to demand their legislature to do an investigation to see whether or not this corporation violated the law of its creation. Okay, here you go. That he was entitled to assert the rights of corporation with respect to the production of its books and papers. We are of the opinion that there is a clear, pay attention, a clear distinction in this particular between an individual and a corporation, and that the latter, the corporation, has no right to refuse to submit its books and papers for examination at the suit of the state. The individual may stand upon his constitutional rights as a citizen. See, it's like, well, are you a citizen or but follow me here. He is entitled to carry on his private business in his own way. Private business? This is the private now. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation so far as it may tend to criminate him. He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life and property. Period. His rights are such as existed by the law of the land, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Period. Not the code, not the statutes, not by any enactments of the legislature or Congress. This is why declarations of rights are bills of rights and are merely declaratory of the common law. It is laying down the law first and then instituting government, as I've showed you over and over and over again. They're separate. The Bills of Rights or Declarations of Rights are separate from the Constitution. Nowadays, they put them together. Well, it's Article 1 of the Constitution of the state of Idaho. No, that's a Declaration of Rights. It's a Bill of Rights. It's laying down the law. And there are other rights retained by the people that are not enumerated here that shall not be denied or disparaged. Don't make fun of me by claiming these other rights. Like saying, oh, that's sovereign citizen. Oh, that's some constitutionalist. That's an attempt to disparage. But look what it says here next. You ready for this? His rights are such existed by the law of the land, long antecedent to the organization of the state, can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. You gotta have a warrant. He owes nothing to the public so long as he does not trespass upon their rights. Well, wait. Well, you're in the public. But he owes nothing to the public so long as he does not trespass upon the rights, a common law trespass. What is the right? What is the conduct that violated the right? And what are the damages? Or you ain't got a cause of action here, Jack Wagon. Now, upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises and holds them subject to the laws of the state and the limitations of its charter. Its powers are limited by law, policy, not the law of the land and not the Constitution, although it is. Like the legislature can't create these departments. And this is exactly what I'm talking about and what the Constitution and our form of government is referring to, granting special privileges and franchises. That's this right here. As part of our fundamental law, because this is a Declaration of Rights, all political powers inherent in the people. We have the right to alter, abolish, reform, or abolish the same whenever they may deem it necessary. And no special privileges or immunities shall ever be granted that may not be altered, revoked, or repealed by the legislature, which is why we go to the legislature for the redress of grievances when these corporations violate our rights. Because watch. On the other hand, the corporation, a creature of the state, is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises, exactly what I just read from the Declaration of Rights, and holds them subject to the laws of the state and the limitations of its charter. Its powers are limited by law, the law of its creation. It can make no contract not authorized by its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation, the policy. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers, not the judicial, the legislature. It would be a strange anomaly to hold that a state, having chartered a corporation to make use of certain franchises, could not, in the exercise of its sovereignty, inquire how these franchises had been employed, and whether they had been abused, and demand the production of the corporate books and papers for that purpose. This is a petition to the legislature for the redress of grievances with any corporation out there to pull the corporate charter and find out if they've exceeded the authority of the law of its creation by the legislature. This is how our form of government is supposed to work. Now, the defense amounts to this, that an officer of a corporation which is charged with a criminal violation of the statute may plead the criminality of such corporation as a refusal to produce its books. The statute is the policy that created the corporate charter of the corporation, the law of its creation. This is why it doesn't apply to the people. It only applies to the corporation and its members. It does not have the force and effect of law on the people or free inhabitants in the private. That's specifically stated right above here. He owes nothing to the public, right? Period. I don't answer any questions when I'm in the private. I'm not on the clock. I'm not getting paid. But if you're in the public with a corporation, I'm sorry, you're bound by the law of creation. And you're bound by the statutes that created you and that govern all corporations of like kind. So all restaurants are bound by a business license, the corporate charter. That's the grant to franchise, to business. And so the restaurants are bound by the statutes. The corporation is. And again, I'll reiterate this again. Oh. Corporations, public and private. Oh, well, I'm a private business. Okay. You got a business license? Yep. Okay. The question is, are you truly in the private? Do you have an open sign? If you have an open sign, you're open to the public. Your doors, like it says in Hale versus Hinkle, the people in the private do not have to open their doors, not even to their neighbor for inspection. But you put an open sign and you're acting in interstate and foreign commerce, well, now you're subject to the statutes, the law of your creation, and you're bound by the societal norms. Okay. This is why the policy powers of the state shall never be abridged or so construed as to permit corporations. In other words, in making the law of creation of that types of corporations, such as restaurants like McDonald's and Burger King and Wendy's and blah, 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 all of them are bound by this specific policy under restaurants of that type. Now, would an athletic club be bound by the policy of McDonald's? No, because they're not in the business of making hamburgers and food. There's a separate franchise, a separate set of policy, public law for them. Each and every one of them has a whole different set of statutes, the law of its creation. But this is what it says right here in today's Constitution of Idaho. that the policy powers of the state shall never be abridged. So this is policy making powers to create shall never be abridged so construed as to permit corporations to conduct their business in such a manner as to infringe the equal rights of individuals and the general well-being of the state. So in other words, they can't create the Idaho State Bar Association. There's no authority to create that. And in fact, it's prohibited from being created in our form of government. All right? And again, the key part here. Right of assembly. The people shall have the right to assemble in a peaceable manner, comma, to consult for their common good, to instruct their representatives, and to petition the legislature for the redress of grievances. So when we petition the legislature for the redress of grievances, we call them into assembly, the General Assembly, peaceably, so that we can consult for our common good here, and so that we can instruct our representatives to perform their specific duties under their emolument, that seat in government. Bound by society by certain duties. They have duties to perform because they're the citizens. Does that make sense, guys? I hope so. Clear as mud, right? But if you know this stuff like I do, and you know right where it's at, and I can cite it, pull it up, put it in a document, and file it, how do you give rebuttal to it? These are facts of law. You can't. Anything that comes in conflict with this is void for any effect, for fraud. And fraud vitiates everything from its inception, void ab initio. Okay? All right, folks. I want to thank you all for being here. Hope you learned something new tonight. Good stuff that you can use. And just want a little plug there. I guess there was a little bit of a glitch in the matrix here on kirkslawcorner.com. I seen a couple different people said that it was down. And I'd actually went and tried to look on my phone, and it did say that it was down. And I'm like, what the heck? And then was like later the next day or something, I jumped on my computer and I'm like, well, it's fine. It's working just fine. So there was some sort of a glitch in the matrix. I don't know what it was. I'm wondering if it had something to do with my internet, because I was actually having a little bit of a problem connecting my phone to my own Wi-Fi internet. It would connect and then it said, oh, no internet. But yet I could come on my computer and I could go on the internet just fine. It was just my Wi-Fi. So it was kind of weird. And I actually reboot my modem. And then my phone still didn't want to connect. So I reboot my phone. And then all of a sudden, lo and behold, it worked fine. So just so you know, there was some sort of glitch in the matrix. And yeah, it's, I believe kirkslawcorner.com is running off of my server now. So, there's we got those documents and stuff on there. If want to download those things, the treatise on arrest and false imprisonment, The Authority of Law by Charles Wiseman wrote both of those. I mean, those are like a prerequisite, recommended, highly recommended reading. I mean, people ask all the time, well, where should we start? What should we read? Those two things right there. Before you read anything else, I highly recommend reading the Treatise on Arrest and False Imprisonment and the Authority of Law. And you can download those for free over there on kirkslawcorner.com. So, for those of you that have been helping support, I greatly appreciate you. I love you. Thank you very much. For those of you who'd like to help support at any time, you can do those postal money orders, regular money orders, cashier's checks, regular checks, anything like that, gold and silver coinage. Send that over to the office at 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. Digital side, PayPal, Kirk_Pendergrass at hotmail.com. Cash App, $, capital K, capital P, EN71. Again, that's the Cash App. And then for those of you who'd like to join me over on Patreon for the Wednesday night workshop, like I said, I've been trying to do that again at 5 p.m. Mountain Time, 4 p.m. Pacific, 7 p.m., 6 p.m. Central, 7 p.m. Eastern. I send out the Zoom link in the messages. So for those of you on Patreon, make sure that you check your messages so that you can get in there. I've been trying to keep it just like 2 hours, but seems we go quite a bit more. But once I get into actually doing the things that I'm wanting to teach people, getting how to write these documents and how to properly file them, that's going to be in the tier 4 or tier 3 and tier 4 people. So be prepared for that, for the switchover. Right now, I'm just kind of getting people on there. We're having discussions. It's a little more private, so I can elaborate a little bit more in the private than I can here. So that's for you folks on Patreon. Special privileges. Thank you for your support over there. And that's Patreon patreon.com/Kirk's Law Corner. Okay. So thank you all for being here, and thanks for your love and your kindness and your prayers and your support. I greatly appreciate it. And pass it around. Share, like, follow, and share both Facebook and YouTube for now. I haven't been kicked off yet. So, but I mind my P's and Q's. I watch what I say, and I try to stick to the law, because that's what Kirk's Law Corner really is about, is teaching the people, educating, and bringing forth the letter of the law as it is written. It's not my opinion. It says what it says as it is written. You know, you got a problem with what I'm teaching here? Provide some evidence to the contrary. I'll change my mind. I am a man of sound mind, possessing logic and reason. You present some evidence to me that's contrary to what I'm teaching, I'll teach it instead. But until then, kick rocks. I will be teaching the letter of the law as it is written. Because, again, I think we need to return to these fundamental principles of law and how this nation called America laid down the law prior to instituting government. Okay? So, I do love you all for being here. Thank you. Much love, everybody. And we'll catch you on Monday Night Law. We'll go back into that commentaries on the Constitution by Joseph Story. Covered a little bit more in there. There's still some more good stuff in there that I want to go over. So, hope everybody has a wonderful weekend. And yeah, it's getting windy out there. We're blowing crap around. It's supposed to rain tomorrow, but we've had some sunny weather the last 2 days, so it's been nice. But Hope everybody has a wonderful weekend. Much love, everybody. Good night.